are ready to start their presentation. During the presentation, all participants are muted. However, you may raise your electronic hand at any point or write your questions, as we are to address these at the end of this presentation. Aurela, hello, can you hear me?
Yes, we hear you.
Okay, I will mute myself now so that there is no interference in between, and please, you're welcome to start.
Okay, thank you. Hello, everybody. We are here to share the experience and practice of Center for Legal Civic Initiatives in Albania in using CEDAW Convention and concluding observations of CEDAW Committee, the Istanbul Conventions and recommendations of GREVIO and UPR's recommendations for Albania as tools for protecting women's rights in Albania. It is a presentation which is structured in 3 parts. The first part is focused in using the Istanbul Convention and GREVIO's recommendations. The second part in using CEDAW Convention and concluding observations of CEDAW Committee. And the last part is how we have used UPR's recommendations as a tool for protecting women's human rights in Albania. Regarding the first one, using the Istanbul Convention, prior of sharing with you how we have used this convention, we would like to share with you that Center for Legal Civic Initiative is an organization established since 1996 in Albania, providing free legal aid for victims of gender-based violence. And based in the problems and gaps identified in providing free legal aid, we have undertaken initiatives in improvement of legislation and improvement of legislation's implementation in Albania. We have organized trainings for judges, prosecutors, police officers, and other professionals of the system, aiming, to be focused strongly on victims' rights and survivors of different forms of violence rights. And also we work a lot with students of law faculties, members of pro bono teams in Albania, aiming to have future professionals more oriented to victims' rights. Let me start with Istanbul Convention. This short information of Center for Legal Civic Initiatives is aiming not just to share with you who we are, but also to share with you how we have used this component, the component of providing free legal aid, as a way to use Istanbul Convention. In our center, we are lawyers who provide free legal aid for victims of gender-based violence. And one of the ways have been that when we prepare lawsuits for the courts of different levels, or when we prepare different official letters for administrative institutions in central and in local level, we are strongly referred to the articles of Istanbul Convention and to the recommendations of GREVIO for Albania. Let me share with you one example on using Istanbul Convention. There are many cases for which we have provided free legal aid, cases of victims of domestic violence or cases of survivors of domestic violence who have been in need of free legal aid for their cases with object dissolution of marriage and regarding, parental responsibility, alimony for children, etc. Regarding these cases of dissolution of marriages, the lawyers of the center are referred to the Article 31 of Istanbul Convention, aiming that the judges of judicial district courts to consider incidents of violence when they decide on the way of exercising parental responsibility, aiming not to let the children for raising and education to perpetrators, fathers, or aiming to restrict their rights of visitation, or another situation has been that the visitation of the children by the father, perpetrator in our cases, to be organized in the presence of the psychologists or social workers. This has been one of the cases. Another example is that the lawyers of CLCI have done attempts to exclude women victims of domestic violence, not having a DV decision yet, from paying the court fees or other court costs. This has been another case. We have a law on free legal aid granted by the state, and we have not yet sublegal acts of this law approved. And this has been, an opportunity for us to prepare acts for the judges and to ask to them the exclusion of victims of domestic violence from the obligation of paying court fees or other court costs. And we are referred strongly in the standards of Istanbul Convention. Another way how we have worked under the frame of this convention has been that the lawyers of CLCI have provided feedback for GREVIO delegations, members of which have come to Albania to listen the voice of civil society organizations. And we have used this as an opportunity to share with them the needs and concerns regarding, the beneficiaries of our services. Another way have been sharing GREVIOs recommendations with all stakeholders. When I say all stakeholders, I mean not only non-state stakeholders, but even state stakeholders, aiming, to translate the recommendations of GREVIO in plan of actions for each of them. And CLCI have provided support for different stakeholders how to prepare this plan of actions, aiming to translate these recommendations in plan of action. And one of the examples is providing feedback for the Ministry of Justice to prepare a plan of action on the implementation of GREVIOs recommendations and CEDAW concluding observations too. This was the first part, the part on using Istanbul Convention. To go on with CEDAW Convention, let me share with you that we have some similarities in using these conventions and the recommendations of their bodies as a tool of change. Regarding using CEDAW, we have done the same. We are referred to the articles of CEDAW conventions and the concluding observations of CEDAW Committee in the preparation of lawsuits or in preparing arguments in different court sessions in the courts of different levels. And we have been very proud when we have seen that our arguments submitted through legal acts, lawsuits of different levels, have been part of court decisions, not just in the legal base, but even in the arguments prepared by the judge to argue the judgment, the court decision. The second point has been using CEDAW in advocacy work of Center for Legal Civic Initiative. We are referring to the standards of this convention in all our advocacy steps that we have done. These standards have been part of statements that we have prepared, declarations. We have been referred to them in media, traditional media, social media too, aiming, to use them as a tool. We have contributed through preparation of shadow reports for CEDAW Committee, being, as an organization, a member of a network or alone as Center for Legal Civic Initiative. One of the examples is the shadow report submitted by Center for Legal Civic Initiatives to the 64th CEDAW session. We selected to report only on 2 points, on 2 concerns, issues for women's rights in Albania. One of the points was the property rights of women in Albania and challenges women face to enjoy these rights. And the second point has been the non-enforcement of the irrevocable court decisions on alimony in Albania. These were 2 concern issues and continues to be concern issues for women in Albania. And we selected these 2 concern issues to share with CEDAW Committee. Another point that we would like to share with you is that we have used participation of the lawyers of Center for Legal Civic Initiative in the 64th CEDAW session to have the opportunity to discuss directly with members of CEDAW Committee and to explain to them how important is the Albanian state to implement the CEDAW obligations and the CEDAW standards. And the final one, we have referred strongly to concluding observations of CEDAW Committee progressively from one concluding observations to the other in our advocacy work. Regarding giving examples, let me share with you that in court cases with object dissolution of marriage, we are strongly referred to the Article 16 of CEDAW Convention regarding equality between husband and wife, and to other and even to other articles of CEDAW Convention. Another example that we would like to share with you regarding the implementation of CEDAW Convention is a concrete case, a case of a woman, BQ, with initials BQ, which was found guilty by the first level courts regarding the prostitution. The Article 113 of the Criminal Code of Albania had foreseen the prostitution as a criminal act, and she was found guilty regarding this. We monitored the implementation of legislation, and we analyzed which were and which are the effects of the Article 113 of the Criminal Code to women and to men, and we found that it affects strongly negatively women and girls. And we raised two issues in the courts. The first issue was to find BQ unguilty. And the second point is that the Article 113 of the Criminal Code of Albania is not in compliance with the CEDAW Convention because it affects negatively women and girls. And we went to the different level of the courts. And one of the requests we submitted to the Supreme Court was to decide that the Constitutional Court to exercise the incidental control and to find Article 113 of the Albanian Criminal Code not in compliance with the Constitution of Albania, and especially with the principle of equality. And what happens was that even that the Constitutional Court did not accept our request to abolish the Article 113 of the Criminal Code. This change consisted in the fact that now in the Albanian Criminal Code, it is foreseen that not only exercising of prostitution is sanctioned with jail, but even buying of these services is part of the Article 113. And our attempts continues on this point. Another example that we would like to share with you regarding using CEDAW Convention is that we are referred to the articles of CEDAW Convention and to the concluding observations of CEDAW Committee in many complaints we have submitted to the Commissioner for Protection from Discrimination regarding gender discrimination and even regarding multiply discrimination, included not only gender discrimination, but also different forms of discrimination due to ethnic or due to race, due to color, or other reasons of discrimination. This is a photo from the 64th session of CEDAW Committee, in which two representatives of Center for Legal Civic Initiative, Professor Aurelia Anastasi and Aurelia Bozo, participated. Regarding other components of working with the CEDAW Convention, we would like to share with you that we also use the opportunity of the non-formal meeting of NGOs with members of the CEDAW Committee, and we had the opportunity to discuss in more details about the concern issues we raised in our shadow report submitted on July 2016. Let me share with you that since November 2017, Center for Legal Civic Initiative is coordinating the monitoring network against gender-based violence in Albania under the frame of a project funded by the European Commission and implemented from CLCI with the support of UN Women. Working in coordinating of this network and working together in a network has reflected in some changes, very important changes that we would like to share with you. The first one is using international standards as tools, now not only as an NGO, as Center for Legal Civic Initiative, but being more powerful in a network which is made of 48 organizations in total, which means more power in lobbying, more power in advocacy, more power in using international standards as tool. What we have achieved is that we are referred to these international standards in the steps we have undertaken and initiatives we have undertaken in the improvement of legislation on elimination of violence against women in line with international standards. This is one. The second one is improvement of implementation of this legislation. The point 3 is we have used international standards as a network to find the Albanian government accountable when the system has failed to provide safety for the victims of gender-based violence. And we have communicated among different organizations, members of this network, to share the good practices on empowering or violating women through advocacy, support, using accessible and quality services too. Regarding using international standards, we started with strengthening the capacities of NGOs, members of this network. Without giving details, in this slide, you will find participation of NGOs in the trainings that Center for Legal Civic Initiatives has organized on UPR, on CEDAW and GREVIO, informative sessions we have organized in the whole country in Albania, a roundtable on CEDAW and GREVIOs recommendation, gender discrimination and property too. So this has been a component focused on strengthening capacities of the members' organizations, and manuals are prepared which are published in the website of the Monitoring Network Against Gender-Based Violence. Regarding shadow reports, it is very important that now from some shadow reports prepared by a small group organizations or 1 or 2 organizations, now we have shadow reports submitted from the Monitoring Network Against Gender-Based Violence, which means a powerful voice of our beneficiaries to these mechanisms, UPR or CEDAW. We have prepared, submitted and presented shadow report for UPR, for which Professor Aurelia will speak to you. And we have also submitted follow-up shadow report for CEDAW Committee. Regarding sharing concluding observations of CEDAW Committee and the recommendations of GREVIO, we have done it in national level with state and non-state stakeholders, aiming, to urge the implementation of recommendations of these bodies. And we have also used as a very good opportunity, and we are very grateful being, members of WAVE Network, because we have had the opportunity not only to learn through being member of this network in a regional level, but also to share our good practices, using the opportunity to share this experience in WAVE newsletters, in WAVE FemPower magazine, focusing especially in using international standards as a tool. This is a photo from trainings in which different organizations, members of the network, have participated. And regarding the component of improvement of legislation, this monitoring network has contributed with suggestions. Some of them are considered in the changes in the law on measures against violence in family relations in line with Istanbul Convention. There are some suggestions closely linked with the articles of Istanbul Convention regarding providing of safety for the victims, regarding, having in focus disabled women faced with domestic violence and other points too. And also regarding the approval of sub-legal acts of domestic violence law, we have used the standards of Istanbul Convention regarding especially risk assessment, risk management, and issuing of preliminary protection order by the police, which is planned, in these sub-legal acts to be issued immediately by the police and to provide safety for the victims of domestic violence, not having gaps in the protection. This photo is a photo in which you will see that some representatives of the organizations, members of the monitoring network, have been in the Albanian parliament to argue why some changes in the law on domestic violence and specifically on this law are important, referring to the Istanbul Convention. The second point that I shared with you before is that we have made positive steps in being together in accountability forums, inviting, state institutions and aiming to analyze the failure of the system and to find the responsible institution and the responsible specialists and to make them accountable. You will see this photo from the Accountability Forum, in which we have had a high participation of civil society organizations and state institutions. We have representative of Interior Ministry, of General Police Department, and we have been, in an accountability forum asking by them which are measures that they have undertaken. Did they found the responsible persons or responsible institutions accountable on non-actions or actions they have undertaken to manage a case, etc. And we are following, step by step, which are the measures that the Interior Ministry or the Police Department of the state has done based in the issues that we have raised in this accountability forum, how they have reflected our concerns in their regulations for the police stations or the regional directorate of police in the whole country. This was what we have prepared regarding the second part, and now we have to continue with UPR.
Thank you very much indeed for this opportunity to share with you some of our experiences in the UPR process or during the process of submission of shadow report delivered by Monitoring Network Against Gender-Based Violence. In fact, this was the first participation of the network at the UPR processes. Why a UPR process? First of all, I would like to say that during the UPR processes, we meet new experiences and new methods. UPR is based on the model of the dialogue between the state under the review and any other UN states. For this reason, it offers a diversity of opinions and a high number of recommendations for the state, for our state, and alternative views, which are obvious during the UPR process. So, based on the UPR process, we can raise concerns on not only based on international standards, but also on different experiences of the states. It helps to bring closer the state and civil society organizations and provides alternative perspectives to human rights. So let's say in the UPR process, our center and our network is still under the process. So we don't have yet the conclusions, and we don't have yet the new recommendations for the state, but we think it's important to prescribe a little bit the procedures we followed in our network to prepare the report, to submit the report, and to collaborate with the state to fulfill the duties in these issues. Regarding the preparation, no, we are on the preparation of the report yet. No, preparation on the second slide. Thank you, Aurela. So, for drafting this report, we have made use of the experiences of 48 organizations of the network gained from the advocacy and services provided to citizens in this field, from monitoring of activities of public institutions on several public awareness and legal initiatives, etc. In this regard, the following instruments have been used. You can see in the slide: preparation of questionnaires, organization of workshops and sharing of ideas, selecting of the issues to analyze from the previous recommendations of the states, which is a very important process for the success of the report, and drafting, discussing, publishing the report. About the report submission. The submission of the report is based on the UPR rules. So we needed to know first the UPR rules and then to submit our report. After that, an important stage, I think, is the publication of the report, because of transparency, but not only for the transparency, but also for the reflection, for consultation process, and for our contribution as organizations of civil society for the fulfillment of duties in the domestic violence, violence against women, on gender equality, etc. So we have published this report in official website of network against monitoring network against gender-based violence, not only in English language, but also in Albanian language. And then is helpful and fruitful the monitoring of the state activities in order to update our statements, because we always are under the process, and this process helps us to update our activity and our contribution. And monitoring of the state activities in order to contribute for the implementation of previous recommendations. How we can contribute during this process? We can influence for fulfillment of recommendation by the state, for example, through awareness campaigns, uses the media, open meetings, open consultations, putting pressures to the competent state bodies in order to fulfill their duties. Make known the results of the process for the civil society organizations, parliamentarians, MPs, embassies, UN agencies in Albania, etc. collaborate with the government by providing our expertise in the field. For example, during the UPR process, after we have submitted the report, we have offered our expertise in drafting sub-legal acts of the law against domestic violence or of the law on legal aid guaranteed by the state, and also on the strategy on legal education, which are very important for the implementation of these acts. We can contribute by participating in consultations with the government, etc., and preparing for the pre-session. Can I continue? Okay. The pre-session is another very important activity of the UPR process, because we have to submit there the pre-session statement, which is a summary of all the report, and which is very helpful for the conclusions and for the new recommendations for the state. So in our model, we have presented some points about the implementation of previous recommendations made by the states, new developments, main concerns on this, new needs, and recommendations. For example, I want to explain all this through the example of the first recommendation we selected to report to the UPR. The recommendation was taking action to effectively prevent and find violence against women, particularly domestic violence, recommended by Algeria, Slovakia, Turkey, and France. So we explained before the participators the new developments, such as the reform of the legislation against domestic violence based on the international standards, new legislation for regulating free legal aid and access to justice, new mechanisms against domestic violence, for example, preliminary protection order or police protection order, and we presented our main concern, which was the gap created between the new legislation and its implementation. So we have a lot of reforms, we have new laws, but we need to strengthen state bodies against domestic violence and their efficiency, especially on local government. Based on this, we presented the following recommendations. First, establishing the referral mechanism against domestic violence in all municipalities of the country, because they are effective only in some of the municipalities of the country, and in some of them they don't exist, and in some of them they are fake. They are not effective. Second, drafting a framework law on preventing and combating violence against women. We think we need now to draft a framework law on preventing and combating violence against women, because till now there is in place only the law against domestic violence, but not a framework law on preventing and combating violence against women. Third, setting up mechanisms in order to implement the new law on legal aid and the amendments of domestic violence law. Especially the implementation of the new law on legal aid is very important because we had a law on legal aid for many years, but we failed to implement it. And finally, setting up mechanisms in order to enforce court decision on protection orders and compensation of victims of gender-based violence. Regarding the last one, we have a process, we have some decisions from the courts, but no one of them is executed till now. So we need to set up mechanisms and to strengthen mechanisms which are not effective in the issue. And let's say, even in general, the issue of the execution of the final court decisions or the implementation of the final court decisions is a big problem in Albania. Remains a big problem in Albania. Okay. Thank you very much for your attention. We are here for your questions or comments, and you can find other information in the website of Monitoring Network Against Gender-Based Violence.
So it's me, Katrina, back. Thank you very much for this very interesting presentation. We have answered one question in the meantime, which was published in the chat, and that was the question on what does UPR stand for, and it stands for Universal Periodic Review, and I've added a link. So whoever is interested to learn more about it, please click on the link and you can search there for more. But let me see if we have any questions now. Show question list.
Show the question list.
Yes, but we don't. Yeah, currently there are no questions, so let me invite the participants. If you have any questions, let us know. You can write them or you can just raise your hand so we can unmute you. We will give you some time to think if you have any questions. In the meantime, I would also like to inform you that precisely in a week, so 1 week from now, on the 29th of May, we are hosting on this same platform another webinar, and that will be on how WAVE within the Step Up campaign is engaging youth and youth ambassadors in our campaigning work. So let me ask you once again if there are any questions. Oh yeah, we do have something. The example with challenging the criminalization of women involved in prostitution is really interesting. Do you know if any other countries have used the same mechanism?
Okay.
Yeah.
We can explain that this was our initiative. We started the work by raising this issue as a public issue, because it's a very delicate issue, and the first request was submitting to the Ombudsman of Albania, and we gained a recommendation of the ombudsman directed to the state bodies. So this happened us to raise, to strengthen our voice against the victimization and against the criminalization of the victim of trafficking. After that, we in fact use, we say, incidental process. So we followed the and exhausted. We have exhausted all the effective remedies in our country for the BQ case, and we achieved that to have a request from the Supreme Court of Albania to the Constitutional Court in order to let's say, to abolish this article into the criminal code. But during this process, because of this pressure made by the civil society organizations, because we were as a network there that time, and made by the ombudsman also, as well as from the anti-discrimination commissioner, and now the proceeding before the Constitutional Court obliged the parliament to change the law, as my colleague explained to you. So I think all this path we have done in this case was a little bit original of Albania, but in our arguments we have used the experiences or different experiences of different countries. So replying your question, we can say that we don't have, let's say, equal situation with another country in our case, but for our case, we have referred the experiences of other countries. For example, Swedish experience and Swedish law, and the evolution of the legislation in different countries of EU countries, for example, Italy, and the evolution of the legislation in Netherlands too.
Yeah, and in addition to what Professor Aurelia shared with you, I would like to share something more about the process. It was very interesting process of working together as a team in our center. And what we did is that we worked a lot with the concept of discrimination and gender discrimination, and based in the monitoring of court decision issued by the court, for years, we analyzed that in a very high percentage of cases there were women, who were faced with this criminal act, and these were not just women, but they were really very disadvantaged women, unemployed, divorced, violated women in family relations, and all of this was used, in our arguments to the Commissioner for Protection from Discrimination or to the courts of different levels, to analyze which were the effects of this criminal act to women and to men, to aiming to explain that even the aim is not to discriminate women, the effects, in fact, are discriminatory for women.
Oh, thank you very much indeed for this question, because we can explain more and more about our arguments presented before the courts that time. For example, we have presented the indirect discrimination and the obligation of Albania to not only to ratify formally the international conventions, but also to implement them. So thank you for this question. And thank you for the comment of Miriam.
question, but before that, I would also like to the next obligate especially bailiff of I don't know what that is, the state to apply the articles of CEDAW during their duty on executing the final decision, especially the order of protection. I hope you can understand this question. It wasn't very clear to me.
Can you summarize?
Yes. We have a problem and we didn't listen to you exactly. Can you repeat your question, please?
Yes, I'm reading from the screen on the right-hand side. If Professor Avila thinks that the changes of the law 9669 on measures against women in Albania are sufficient to provide and minimize this phenomena in Albania.
Okay. You can reply.
If we understand the question well, because as I told you, we had a problem in listening your question, but I can repeat how we listened it. Is the law on domestic violence sufficient in providing protection for the victims?
And executing the
execution of court decisions?
Can you answer these questions?
Do you hear me, please?
Yes, yes.
Okay. I understood the question that if the law against domestic violence is sufficient to provide protection for victims of domestic violence and to execute protection orders. Am I right?
Yeah.
Okay. We have many problems, in fact, with the implementation of legislation against domestic violence in Albania. But as we shared with you, we have some recent changes, very important ones. The first one has to do with the risk assessment and risk management, and based in this risk assessment, a plan of safety will be designed for the survivors, aiming to provide safety for the survivors. So we hope that these recent changes will contribute in a more effective safety for the survivors of domestic violence. Because in the past, the victim of domestic violence had to wait for 48 hours to have a decision of the court, urgent protection order. And now we have the opportunity that immediately after risk assessment, when the police analyze that the survivor is in high level of risk for her life, they have the opportunity to issue immediately a preliminary protection order which will be confirmed by the courts. So we now do not have gaps in having a protection order, and we hope that this will contribute in providing safety. This is one point. Another very important point is that under the frame of this law against domestic violence, there are established mechanisms, referral mechanisms on managing cases of domestic violence in local level. So we have done very important steps in managing in a coordinated way cases of domestic violence, but the problems that we have are some. The first one is that we have 61 municipalities in Albania, and up to now we have only 39 referral mechanisms. So at first we need to establish these referral mechanisms with representatives with all institutions in local level in all municipalities in Albania, the first point. And the second point, to increase the effectiveness of the existing ones referral mechanism. This is one point. Another point is that we have problems even with the enforcement of the court decision of protection orders, urgent or normally protection orders. So in this duty, we have three institutions responsible. We have police, we have bailiff service, and we have the Office of Social Services near the municipality. All of them are responsible of protection orders, and we need that the coordination among them to be strengthened, aiming to provide safety for the victims of domestic violence, and even to implement different measures foreseen in the court decision, which are not only regarding safety, but also regarding, rehabilitation of the perpetrator, the care and attention for children, etc. Another important challenge that we are facing in Albania is the lack of social services. But in our country, we are in the process of reforming social services, and we are doing many attempts, state and non-state actors, aiming to have these social services near the victims, to have the services to a rural woman who is faced with domestic violence. Not to have only a shelter in Tirana, a state shelter in Tirana for victims of domestic violence, because the access of the victims who are far from Tirana is low, but we are working a lot in cooperation with the Albanian state to have social services, the benefit from social fund, aiming to establish and finance these social services, and the most important one, to have these social services near the survivors of domestic violence in the whole country, aiming to have them accessible.
Just I want to add that in the new amendments of the law against domestic violence, we have new tools, new possibilities in order to execute or to implement the court decisions on protection orders. So now we need to strengthen all the mechanisms foreseen there with more precise responsibilities and the monitoring as a tool, and the report as a tool of social workers, the report of social workers as a tool. And we need to strengthen all of these tools in order to have effective execution of protection orders and immediate protection orders issued by the courts. But you know that the law is important, and when we have participated in the process of amending this law, our aim was to foresee other tools and to strengthen the tools foreseen by the law for the execution of the protection orders. But the implementation is another important process for the success of this execution. Thank you.
Very thorough reply. We have had a raised hand, and I would like to try to give to turn the microphone on for Esmeralda. Okay, I think your microphone is on, so you can. Hello, can you hear us, Esmeralda? Hello. Yes, if if she cannot hear us, just in case, then I will turn the microphone off. I wasn't sure. I understood that the raised hand meant that she would like to go live and tell her question, but if not, then I will just turn it off. Do we have any other questions? Aha! It looks that something is not working. Is it possible that you type your question if your connection is not really working? Oh, can we try once again? Okay. Yeah, just type your question, please, then. So we're now approaching 1 hour of this webinar. So if you have any other questions, please make sure you type them. What about the state bailiff service? And she's typing a little bit more. So as for my information and our work, it doesn't work properly in our country.
Yeah, thank you very much, Esmeralda, for your question. I agree with you that up to now we have had many problems with the bailiff officers in the execution of the court decision for protection orders. Sometimes we have had discussions about the responsibilities of different state bodies, such as a discussion between the police and the bailiff officers. And we have had in clarity their duties were not clear, and the interpretation of the law was different, made from the bailiff office was different from the interpretation that the police officers or the court has done. And so these problems we tried to resolve a little bit in the new amendments of the law against domestic violence. Now we have foreseen the different responsibilities for the state bodies which are responsible for the execution of the protection orders, such as police, local government, and bailiff office. So the bailiff office responsibility is more clear now, referred by the new amendments on the law. It remains that they should prepare to implement the new amendments and to collaborate with the local government and with the police during the execution of the court decisions. For example, when we need the help of the bailiff officers to execute the protection orders, which have foreseen to accompany the woman to the shelters, we need the help of a bailiff office. So there are some duties which can be executed by the activity of the bailiff officers. Let's say the main state bodies for the execution of protection orders are police and local governments, and the referral mechanism against domestic violence, or the coordinator against domestic violence near the local government. But when they need help, they should ask to bailiff officers. So
It's a challenge.
it's a challenge, yeah, for the future.
Yeah, we are working a lot in the referral mechanisms in local level, in the existing one, in 39 that I shared with you, to strengthen the role of representative of bailiff services in these referral mechanisms, because not in all of them we have the bailiff service very active, and we would like that the coordination of this service with other actors to be strengthened, aiming, to manage cases in a coordinated way, and to contribute to safety of the victim and the enforcement of protection order, urgent or normal one.
For example, the right to visit the children, the right of the parents to visit the children should be monitored by the bailiff office. Yes, I think yes.
Yeah. Do you hear us?
Yes, yes. Okay. Albana country.
Okay. Another question that we have received is that if in our state we have, mechanisms and tools for rehabilitation of victims and rehabilitation of perpetrators. So, do you hear us? Yes, okay. If you are hearing us, we have to share with you that we have shelters, a state shelter and shelters established from NGOs for victims of domestic violence and victims of gender-based violence. We have a center for victims of sexual violence, which is established in the hospital in Albania and provides support for victims of sexual violence, which is really very important. The standards of working in this center are approved with the decision of the Council of Ministers. And regarding the rehabilitation of the perpetrator, let us to share with you that we have, in fact, rehabilitation programs for the perpetrators in Tirana from the Center for Rehabilitation of Men and Boys, established from a non-profitable organization in Tirana. We have in Shkodra also, from Gruaja to Gruaja, and we have had also in Elbasan. So we are working a lot as civil society organizations to establish not only rehabilitation centers for victims of domestic violence in the whole country, but even for rehabilitation of perpetrators. And as lawyers, we are asking by the court to foresee in the protection orders measures, and one of them is to urge the perpetrator to attend rehabilitation programs. And according to our legislation, if the perpetrator is not attending the rehabilitation program for which it is obliged by the court decision, then it is a criminal misdemeanor and the sanction foreseen is up to 2 years. Okay.
Okay. Okay. Could you hear me?
Between, yeah, just to.
Now we are hearing you.
Yeah. I muted myself in between because otherwise it's too much noise.
Okay.
So yeah, that's why I'm muting myself in between. Yeah. Thank you. I hope this reply is has answered your question, Etleva. Do we have any other questions? I mean, even if you think of any other questions in, after this webinar, just all the time you're free to, feel free to email us, and we'll make sure that we forward your email to the presenters and that you get your reply. If there are no more questions at this point, I would then like to thank very much to our brilliant presenters and send you my big waves to Tirana from Vienna. So we're very happy to host you and to even reveal that this is actually our first webinar with co-hosting. So there was also kind of a test of how this works from a technical point of view. And also, I would like to thank all the participants for taking part and for posing very interesting questions. And please, yes, feel free to, if you think of any other questions during this afternoon and after the webinar, to let us know about them. Thank you all very much, and I was very happy to see you, or to be with you in this webinar. I wish you a good afternoon and goodbye.
Thank you.
Thank you.
Goodbye.
Goodbye.
Goodbye, everyone.